Someone was asking about crisis situations in Hindu marriage. What are the crisis situations in Hindu marriage? Crisis areas. So you can see there are three types of crisis situations that you can think of. One is void marriage. If marriage is going about in normal course, no problem is there, then that wouldn't amount to a crisis situation. Crisis occurs when there is problem so far as the status of the marital relationship is concerned. So void marriage is one crisis situation in marriage. Voidable marriage may arise like a crisis situation depending upon the choice of either of the party to the marriage, and dissoluble marriage. Dissoluble marriage. In void marriage, the marriage is non-est. It is void ab initio. Void means nothing, zero. And void ab initio means nothing from the beginning, non-est from the beginning, void from the beginning. So because of the non-fulfillment of, or because of the non-compliance of certain conditions, a marriage solemnized between two Hindus is a void marriage. We will see those conditions. And if either of the party approaches the court, then the court will issue a decree of nullity, a declaration that your marriage is a void one, it is void from the beginning itself. So far as voidable marriage is concerned, here also decree of nullity can be issued by the court on the application of either party to the marriage. If the aggrieved party, if the party who happens to be aggrieved because of the non-compliance or unfulfillment of certain conditions, can approach the court and have his marriage declared null and void. But this one, the marriage falling under the category of void marriage, is illegal, is against law, is nothing, is non-est, it is void ab initio from the beginning itself. Even if the court doesn't declare it to be so, the marriage will be regarded as nothing in the eyes of law. This is called void marriage. So far as voidable marriage is concerned, a voidable marriage does have some drawbacks. But if both the parties to the marriage are living happily together, they have no grievance at all, then this sort of marriage will continue on and on without any hassle, without any problem, without any risk of annulment at such. And so far as dissolution of marriage is concerned, here party either mutually or single-handedly can approach the court in order to seek a decree of divorce. So by means of a decree of divorce, the marriage is dissolved. What are the conditions, or what are the conditionalities or grounds on the basis of which a marriage can be uh, declared or dissolved by a decree of divorce? We will see that shortly. But these are the three crisis situations in a Hindu marriage, which may ultimately result in, which will ultimately result in the marriage being declared void, the marriage being declared null and void, or the marriage being dissolved by the decree of the court. Regarding void marriage, we will have to see that regarding the void marriage, we will have to cast a look at section 5 of the Hindu Marriage Act, HMA, Hindu Marriage Act section 5. Section 5 through its 5 of the clauses provides for conditions of marriage. Conditions of marriage. That what all conditions are required to be fulfilled in order for a marriage to be solemnized validly. The first condition is neither of the party has a spouse living at the time of the marriage. A spouse means for husband, the wife is a spouse, and for wife, the husband is a spouse. So the intending party to the marriage, suppose A and B are the intending parties to the marriage. A is male and B is female. These two are intending party to the marriage, right? The condition here is neither A nor B should be having a wife or a husband as such, living at the time of the marriage. Suppose A is having a wife already in the name of W1, then A and B cannot possibly marry validly. Because A is having a wife living at the time of the marriage with B. And even if A and B were to decide that B will go on and marry, then this marriage will be void in the eyes of law. This marriage will have no meaning in the eyes of. Similarly, suppose if B is having a husband from previous time and the name of the husband is H1, and despite that, if B and A together were to decide that they will marry, then their marriage will be void from the beginning itself. It will have no value, no meaning in the eyes of law. Because B is, in the second example that I gave you, the B is having a husband already, and that husband is alive. Therefore, B is not capable to marry. B is not eligible to marry with A validly. If, despite there being a living husband or wife, the party to the marriage enter into or solemnize marriage, then this marriage, the law says, be it section 11 of the Hindu Marriage Act. In section 11 of the Hindu Marriage Act says that a marriage solemnized in violation of the clause 1 of the section 5 shall be void. In fact, it will be void ab initio. So this is one is section 5 clause 1, in a manner of speaking, constitutes an absolute condition. No violation will be tolerated here. No defiance of this provision shall be countenanced here. Right? So this clause ensures in our corpus juris the rule of monogamy. Previously, prior to the coming into effect of the Hindu Marriage Act in 1955, polygamy was usually practiced by people in our country, Hindu people in our country. Polygamy means having more than one wife. Now, if you are already having a wife, you cannot solemnize marriage with a second for a second wife. So you cannot have two or more than two wives at one and the same time. You will have to have only one wife, and if she is alive, if she is living, if the marriage with her is continuing, then a male person cannot marry to have a second wife. So this in a manner establishes monogamy in our country. Monogamy in Hindu society. Monogamy has now become the absolute rule. Any departure or any deviation from the norm of monogamy is bound to attract punishment. The crime will be known as bigamy. Now the second condition here is, if either party is suffering from any mental condition, like because of being of unsound mind, either party to the marriage is not in a position to give consent to the marriage, to give consent for the marriage, or even if either of the party is capable of giving the consent, but he or she is not capable of understanding the nature of the consent that he is about to give, the nature and effect of the consent he is about to give, and not able to perform the requirements of marriage, not able to understand the nature of marriage as such, or under the attack of under the recurrent attacks of insanity. He is not constantly of unsound mind, but from time to time he suffers attack of insanity, madness, attack of madness from time to time occurs. A person having any kind of mental condition is not eligible to marry validly, right? But even if suppose parties, intended parties are agreeable, they are happy with one another, then they can marry, of course. And this marriage will not be a void marriage, but it will be a voidable marriage. Voidable marriage means depending upon the choice of the party who is aggrieved, the court can declare such marriage with unsound mind person as void. Otherwise, such marriages are okay, they are valid, they are regular type of marriages, they can continue and on and on if the parties continue or stay agreeable to one another. The third condition is regarding age. Minimum age for the bride is 18 years and for the bridegroom is 21 years. Thanks to the amendment made into the Hindu law, Hindu Marriage Act 1955, in the year 1976, this amendment was enacted, and the minimum age requirement was incorporated into the law. In fact, the law says that the bride must have completed the age of 18 years. Must have completed the age of 18 years. Means she must have entered into the threshold of 19 years. And the groom must have completed the age of 21 years. A marriage solemnized in violation of this condition is not an invalid marriage. In fact, it is a valid marriage, but it is a punishable kind of marriage. Penalty is bound to incur. Penalty can be visited upon the party to the marriage and the people who participated in the performance of the whole exercise. They also are liable to punish for having managed and conducted the process of child marriage. So child marriage as such is not the child marriage as such is not an invalid marriage. It is a valid marriage, but only risk is that of penalty being incurred either for the party to the marriage or for the parents and the other persons involved in the whole exercise. Now let us come to the fourth condition in order to understand or appreciate this point of void marriage. So these two conditions, condition 2 and 3, are not related to void marriages, right? Condition 4 is related to void marriage. So for the sake of clarity, let us erase them. In fact, condition 2 is of no significance, is of no relevance when we are on void marriage, and condition 3 is also of no relevance when we are on the subject of void marriage. Condition 1, 4 and 5, they are material so far as void marriages are concerned. So let us see what is the fourth condition as specified in section 5 of the Hindu Marriage Act. The clause 4 of section 5 of the Hindu Marriage Act says that parties to the marriage must not come under prohibited degree of relationship. And the fifth condition is parties to the marriage should not be in subpenda relationship with one another. Prohibited degree of relationship and subpenda relationship, these two expressions in fact connote close relationship between parties, close relationship between the intending parties to the marriage. A brother and sister cannot marry because they are in close relations. A person cannot marry with his auntie because they are in close relations. An uncle cannot marry, solemnize marriage with his niece because they are in close relations. Right? So, in this manner, the simple rule is, the general principle is, persons coming under close relationship cannot marry. This has been the custom all along in India, in Hindu society. Persons of close relations cannot. Now, in order to signify the closeness of relationship, these two important words have to be looked at. The first one is prohibited degree of relationship. What actually is meant by it? And what is the meaning of subpenda relationship? Well, we do not have to invent our own type of meaning here. The meaning of these two expressions have been given in section 3 of the Hindu Marriage Act itself. Mind you, the Hindu Marriage Act 1955, in its section 3, contains a definition clause. It's a definition clause. Because Hindu marriage practices related to marriage and divorce among Hindus is mostly guided by customs and usages. Therefore, several words of ancient connotations have been defined here. For example, section 3, clause A defines uses and custom. Uses and custom. Uses and custom signify any rule which, having been continuously and uniformly observed, has obtained the force of law among Hindus in any area, tribe, community, family, or group, etc. So, any ancient rule which is reasonable, which hasn't been discontinued, and which is certain, can be regarded as uses and custom. And usage and custom have been given sufficient recognition in the Hindu Marriage Act 1955. It means marriage can be performed according to customs. If the custom is reasonable, if the custom is not against public policy, if the custom is not against the provisions of the fundamental rights contained in the Constitution, if the custom is certain, if the custom is ascertainable, right? So, custom and usages still govern the area of solemnization of marriage and dissolution of marriage both. The condition is, the custom must not be unreasonable, it must not be against public policy, and it must not be violative of the rules contained in the Hindu Marriage Act 1950. Suppose you are a male person, and according to the custom prevalent in your family, your society, your caste, your area, male persons in previous times used to have more than one wife. This has been the custom in your area, in your family. But you cannot now lay claim to this fact that I will abide by this custom, because you cannot insist so. Because the law is now that you will have to have one wife only. During the subsistence of one marriage, you cannot solemnize another. Monogamy has now become the rule. So, at the cost of the rule contained in the Hindu Marriage Act in the form of monogamy, you cannot practice polygamy just because there has been a custom prevalent in your custom. If it be found to be violative of the provisions of the Hindu Marriage Act, or if it will found to be violative of the provisions of the Constitution, particularly fundamental right provisions, then that custom will not be allowed. Otherwise, if the custom is reasonable, if the custom is in accord with the public policy, if the custom is not violative of the fundamental rights, then that custom can be practiced, it can be acted upon, and marriage can be accordingly solemnized. So far as clause B of section 3 is concerned, that is not of much significance. The definition of district court has been given there. In clause C, full blood and half blood have been defined. We are not concerned with that as of now. In D, uterine blood relationship by uterine blood has been defined. So far as E is concerned, the meaning of prescribed has been given, that is of not any significance to us. So far as the clause F and G are concerned, in F you have the definition of subpenda relationship, and in G you have prohibited definition of prohibited degree of relations. Now let us come to that point. A person, if the parties are related to one another and in one another within the meaning of prohibited degree of relationship, then they cannot marry. Uncle and niece cannot marry because they come under the degree of prohibited relations. A grandfather and a granddaughter cannot marry because they come under the purview of the Sapinda relations. So the meaning of these two expressions have been given in section 3 of the Hindu Marriage Act. So far as prohibited degree of relationship is concerned, if one is the lineal ascendant of the other, then they both come under the prohibited degree of relations. The granddaughter and grandfather. The grandfather happens to be the lineal ascendant of the granddaughter. They cannot marry because they are within prohibited degree of relationship. Of course, it seems very, bad in taste that a grandfather would marry with his granddaughter as such, but imaginary example let us give to be able to understand the whole gamut of the legal provisions. Imaginary examples can be given. So if a person is the lineal ascendant of the other, then they both are to be regarded as in prohibited degree of relations. The wife or husband of the lineal ascendant also come under the prohibited degree of relations. Brother and sister, uncle and niece, aunt and nephew, they all come under the prohibited degree of relations. Because of the closeness of the relationship, they cannot marry validly. So far as Sapinda relationship is concerned, regarding Sapinda relationship, it has been said in section 3, clause F, that with reference to a person, a person is said to be the Sapinda of another if from the line of ascent through the father, if they come under the 5 generations, the counting starting from the person himself, or from the mother side, if the person concerned comes under the 3 stages, 3 generations of the relationship, then that will be called Sapinda relation. Here also you will see the closeness. The closeness is what is indicated in the form of prohibited degree of relationship or Sapinda relation. So if a marriage is solemnized in violation of clause 1 of section 5, clause 4 of section 5, clause 5 of section 5, then in that case that marriage will be void ab initio. Of course, people bound by prohibited degree of relationship or bound by Sapinda relationship can marry if their custom allows them to. Otherwise, the law is you cannot marry if you come within the prohibited degree of relationship. So far as Sapinda relationship is concerned, you cannot marry if you come within the meaning of the Sapinda relation. So these are void marriages according to section 11. A marriage solemnized in violation of clause 1, 4 and 5 contained in section 5 of the Hindu Marriage Act are called void marriage, and if either of the party or both of the party approach the court, then the court will have occasion to declare their marriage void ab initio by a decree of nullity. Now let us come to this aspect, voidable marriage. What is voidable marriage? For voidable marriage, we will have to understand the whole area, the whole gamut of voidable marriage. We will have to cast a look at section 12. Section 12, subsection 1. A, B, C, D. 4 conditions are there. They indicate sufficiently what all are voidable marriages. A marriage which has remained unconsummated due to the impotency of the respondent. Impotency can be attributable to husband or wife. Both can be important. Either of them can be impotent. Impotent means not capable to perform sexual intercourse. To consummate means to perform sexual act. To perform sexual intercourse is what is known as consummation. One is solemnization of marriage, when intending parties solemnize their marriage. They do what? They celebrate, they perform their marriage according to the rites and ceremonies applicable to them. That is called solemnization. Solemnization of marriage marks the beginning of the marital bond. The marriage starts, the marriage gets up to start from the date of the solemnization. But this marriage, in a manner of speaking, assumes real value when the marriage is consummate. Consummation is as much a significant stage so far as the status of marriage is. A marriage is required to be consummated in natural. Sexual intercourse has to be performed. Otherwise, the ultimate goal of marriage will stand defeated. The ultimate goal of marriage has long been regarded as procreation of children. This is the ultimate goal of marriage. Of course, deriving sexual pleasure and bliss is also a part of marital life, important part of marital life, but the primary object of marriage is to procreate children, to give them certain identity, right? So marriage in natural course is required to be consummated. Sexual intercourse has to be performed. If the husband is incapable to perform sexual intercourse, then the marriage will remain unconsummated. If the wife, due to some mental physical condition, is not capable of performing sexual intercourse, then the marriage will remain unconsummated. So an unconsummated marriage, the parties to an unconsummated marriage can live their life as normal couple. If they both are agreeable, they can live without sex. There is no need to have the marriage declared null and void as such. There is no need to have children. They can become agreeable to this aspect. But if either of them chooses to approach the court, then the court will have the right to declare their marriage null and void by way of issuing a decree of null. So this marriage, based on the afflicted with the drawbacks contained in section 12, such marriage are regular marriages, valid marriages. No problem if parties are agreeable, if parties are living happily together. But if any of the conditions is to be relied upon by either of the party, then the marriage can be declared null and void. If the husband is incapable to perform sex, wife can approach the court that, see, our marriage has remained unconsummated. I want to have a decree of nullity. Let the court declare this marriage null. The court will have occasion to do so. The second condition here is either of the parties of unsound mind. Then the respondent is of unsound mind. Suppose if the husband is of unsound mind, the wife can approach the court to have the marriage declared null and void. If the wife is happy with the mental condition, whatever mental condition of the husband, then there would be no problem. Vice versa, you can also give the example. If the wife is of unsound mind and if the husband is quite happy, quite agreeable, no problem would perhaps occur. They will both live happily together. But if due to unsoundness of mind of the respondent, the petitioner approaches the court, the aggrieved party to the marriage approaches the court, then the court will declare that marriage null and so this marriage based on unconsummated status or any party to either party to the marriage being unsound mind are voidable marriages. And so is the situation so far as the conditions C and D is concerned. What is there in C? If the consent of the petitioner was obtained either by force or fraud as to the nature of the ceremony or as to any circumstance, any material circumstance concerning the respondent. Some force was used in order to compel one of the party to enter into marriage, to solemnize marriage. Some misstatement of fact, some fraud was practiced upon the petitioner to obtain his consent, right? So if force or fraud is discovered by him, then the law requires the petitioner to approach the court within 1 year period of the discovery of the fraud or the cessation of the applying of the force, and the court will then have occasion to declare that marriage null and void. So far as the fourth condition is concerned, that is pre-pregnancy. If the respondent means if the wife to the marriage was pregnant from before, prior to the marriage she was pregnant from somebody else, then in that case also the aggrieved husband can approach the court and have his marriage declared null and void, because this is also a kind of fraud that was practiced upon him. A pre-pregnancy, pregnancy from a previous time, is a vice, not a virtue. If the male person becomes agreeable to the pregnancy, then certainly there would be no problem. But if the husband feels aggrieved that you did not let me know that you were pregnant, now I am coming to know of it, I protest, I do not want to live with you. In that situation, the husband can very well approach the court and have his marriage declared null and void. But the law says in section 12, subsection 2, that once you discover the fact of pregnancy from previous times, then within 1 year you must approach the court. Otherwise, you will not avail of yourself any remedy from. So far as the third crisis situation in terms of dissolution of marriage, which is granted by decree of divorce, is concerned, we will see that in some other lecture.